Thank you, Catherine. Okay, I think you've absorbed a lot of news already, so it's just about time for a quiz and then raffle prizes. Before I give you the quiz, though, you're going to see what sort of answers our colleague Benno Glasser got when he interviewed folks on the street about healthcare reform. So let's look at Ben's person on the street interviews, and then you're on the spot.
Hi, I'm Benno Glasser of Bullard Law, and I'm out on the streets of Portland asking people questions about the legal issues you'll be hearing about at today's briefing. And do you know what the Cover Oregon dispute is all about?
Not very much, no.
Okay, what do you know about the Cover Oregon dispute?
Pretty much nothing.
That's a good question. I'm not really quite sure. I know that things are different now under the Affordable Health Care Act, but yeah, I'm a little fuzzy on the details. I just know that for sure what happened along the line was Oracle screwed it up somehow.
When you go to see a doctor, does your supervisor get to find out the reason why you needed to see a doctor?
No. One word, HIPAA. No, you cannot know why I went.
Of these two gentlemen, who would you rather have as your lawyer? Option A or option B?
B.
And why is that?
He has a beard. He looks friendly.
Yeah, he looks friendly.
Does option A look friendly too, though?
Kinda, yeah.
He looks like he would, I don't know.
Who are these fellas? We should know them,
Yeah.
I'm sure.
Option B.
And why?
I don't know, I like beards. I don't know.
Okay. Back to you guys in the studio.
First question is, how many people do you think we had to interview to get to the people who answered B? No, Dave Rewald isn't here, and so I can say whatever I like about those two photos that Ben showed folks. Now, this is a 10-question quiz. You see it in your materials about healthcare reform, and Dan Rowan has already given away the key piece of information, and that is there are new pictures of cats this year. Okay. Let's see if I can make it work. Okay, I always like to begin with a picture of myself, so that when you think, gosh, you know, who was that guy? You say, oh yeah, it was a fake news guy, and there he is. Let's go from there now to my picture of you. So again, you have an idea of what it feels like to be up here, even though you're not up here. I hope you're not planning to storm the stage, but if you were, that's what it would look like. And then here we go. Here's our 10-question quiz. If you've been studying, if you brought your laptop, here's a picture of you. Okay, question 1. There it is. I'm sorry, I'm having trouble with the clicker. Employers, and it's a statement, true, false, or partly true, employers must offer medical coverage to their full-time employees starting in 2015. How about a show of hands? Anyone say true? Well, you can do this. False? Oh, wait a minute. Partly true? Okay. I was afraid you'd gone to sleep or were just being sullen out there. And I've already told you I'm having lunch with our daughter for her birthday, so I'm used to that. But you're starting early. Partly true. Employers must offer medical coverage. See, I would have said false, because even under the play or pay rules, employers don't have to offer coverage. You might have to pay a penalty if they don't, but it's not a mandate to offer coverage, I would have said. So I would have said false, but false includes partly true, so good for all of you who raised your hands there. And that's what I say to you in response to your answer. You did just fine. I included family pictures here just so you'd get to know us a little bit better. Okay, question number 2. Applicable large employers, those employers that are subject to the shared responsibility rules, or so-called play or pay rules, are those with at least 50 full-time employees. Okay, how about raise your hand for true? Okay, false? Partly true? Yeah, okay, so the effect of the first question was you decided, okay, if you're going to make fun of me for it, I'm not raising my hand. I'm with you. I would have concluded the same. I would have said partly true on that one. So the person who raised their hand like a lawyer did absolutely the right thing. because of course it applies not just, what you're thinking is it doesn't apply just to people with 50 full-time employees, but 50 full-time equivalent employees. So it could be a bunch of those part-timers adding up to full-time equivalent person might take us over that 50 threshold to be an applicable large employer. Okay, I understand your response to that question. I saw actually that in the way you didn't raise your hands, and so here's a picture of you to recognize that. Question 3. Let's take this. Okay, so these applicable large employers, the ones who are subject to the player pool rules, they have to offer medical coverage to their full-time employees starting in either 2015 or 2016. What do you say to that one? True? Raise your hand for true. Okay, raise your hand for false. Good, all right, and partly true? Yeah. Okay, so it's minimal, or as we say as lawyers, de minimis. I promised actually that I would use that as many times as I could today. I was going to actually apply it to the present I've given our daughter at lunchtime today. Well, so again, I would say the key is the must offer. They don't have to offer medical coverage. They either offer medical coverage in 2015 if they're 100 plus, or if in 2016 if they're 50, between 50 and 100. But they don't have to offer coverage. They either offer the coverage or perhaps they pay the penalty. Okay. So again, another picture of you. I think this has been your response to the question so far, but let's see how you do with question 4. They're all trick questions. I mean, if you want to know which one is a trick question, the answer is all of them. Question number 4, if you have 100 full-time equivalent employees or more, your player pay deadline is January 1 of 15. True or false, you think? True, false, partly true? True? Raise your hand. January 1, 15 deadline. False? Don't think that's the deadline. Partly true? Okay, so the person who courageously raised her hand for partly true, she and I are together. That doesn't mean she's right. It just means that we're together being wrong. But you have company, ma'am, and I'm glad to have the company myself. I would have said partly true. The general deadline is 1 of 15 for all you people said true. You are mostly right. A little dogmatic, but mostly right. Because that's the general deadline. If you have a fiscal year plan, if your plan runs, say, on a July 1 to June 30 or December 1 to November 30 year, you might actually get more time until the beginning of your plan year starting in 2015. So it is, think of it, you're right to be thinking of it as a 1/1/15 deadline for those 100 plus employers. But if you have a fiscal year plan, you might have more time. And even if you have a calendar year plan, if you get the folks enrolled in this first year by April 1, you're still good. So if you're despairing of getting folks enrolled by January 1, but you can do it by April 1, you're probably still going to be fine under the player pay rules. Okay. What you thought is, if he talks more like that, I'm just going to answer the questions, check the boxes, and leave. There's a picture of our grandchild. Question 5, is this applicable large employer? They might be subject to what I've called the inadequate offer player pay penalty, the penalty for not offering coverage to enough people. And they might be subject to that penalty unless they offer affordable minimum value medical coverage. Unless they offer, so an applicable large employer, the rules apply to them, and the key to avoiding that inadequate offer penalty is to offer affordable minimum value coverage. True? False? Partly true? Yeah, okay, so that was sullen. I took that one to heart. I would have said, you could answer partly true or false. If they, and those of you who answered true, you did fine too, because if you offered affordable minimum value coverage, it's sort of like a Unitarian quiz. All the answers are good. Or Lake Wobegon quiz, all the children are above average. If you answer true, you're right. If you offered affordable minimum value coverage, you satisfy the inadequate offer. But all you have to offer is minimum essential coverage, which is something very different. Basically, any employer health plan other than, say, an HRA, health reimbursement account, or health flexible spending account, or dental and vision only, almost any employer plan, as long as it provides certain preventive coverage, is going to be good enough. Doesn't have to be affordable, doesn't have to provide minimum value for purposes of this inadequate offer penalty. It's only the affordability and minimum value penalty that applies for those purposes. So you're back to studying now. I know you're looking up the answers even as we speak. Those of you who have smartphones, I don't, so it's hopeless. So we're going to go on to question 6. How about an employer says, look, buying this health insurance is just too difficult. My health plan is going to be an HRA, a health reimbursement arrangement. I'm going to set money aside out of my own pocket. Employees don't have to contribute a thing. In fact, they can't. I'll just set some money aside and they can take their money and go buy individual coverage, either on the open market or at Cover Oregon, whatever the heck that is. We obviously don't know. The person in the dark shirt and the tie that they interviewed, I didn't tell Ben, but that's actually our son. What about this? True that an employer can say, my health plan is a health reimbursement arrangement where I put money in and employees can use that money to go buy individual coverage. True, false, or partly true? How about for people who say true? Yeah, I can do that. Good. Not answering that one, and for whatever reason, you're making the right choice. False? People who say, no, that's just wrong. You can't do that. See a few brave hands. Partly true? Yeah, well, false is the right answer. And so the one person who actually was willing to give the answer was right, which means all of you win. That's right. Because of the annual limits rule, the rule that says you can't have a health plan that has annual limits, and HRAs almost always do have annual limits, annual dollar limits. So not permissible, actually starting this year in 2014. So that's how much good the study did you, I'm afraid. Okay, question 7, or at least getting through them. I remember sitting down in an economics class to a Blue Book exam, and the best thing I thought after I read through all 3 questions was, 3 hours from now, I'm going home. I actually thought I'd walked into the wrong room by mistake because those questions didn't relate to anything I'd studied. That's how much I still know about economics. How about this? Employers' health plans must permit enrollment after not more than 90 days. 90 days, that's that you have to let people enroll in the health plan after 90 days or less. Anyone say true? Okay, good. That's a logical, incorrect answer. How about false? Given what I've just said. Well done, yes. It was just a hint. And partly true? All of you who re-raised your hands who said true to partly true, you did well. You read the signs. That's right. You're right that the maximum waiting period is 90 days, and good for you for catching that. You can still keep people out of the plan for other reasons. We can say, we don't let lawyers in the plan. They're too expensive, especially now with mental health parity having no cap. After all, they could be recovering lawyers. So that they might be out of the plan, not just for 90 days, but permanently. And so you're right that it's a 90-day waiting period, but exclusions still allowed in your plan. If you're a large employer, maybe excluding those lawyers would subject you to a play or pay penalty. And certainly I hope that it would. Okay. That's how much good the studying does our cat, the 17-pound tuxedo cat. I don't think I gave you a picture of Harvey, also known as the fat man. Question 8, showing that you're almost there, is those applicable large employers, they can use measurement periods, so-called measurement periods, to determine when to offer medical coverage. So they can use a measurement period to say, look, we'll wait and see during the measurement period to see whether either we offer you coverage or you can go to the exchange and trigger a penalty. Can how about this? True, it's you can use measurement periods to determine when to offer coverage if you're an applicable large employer. False, you can't use measurement periods. Partly true. There aren't going to be other choices. Okay, here's choice D. Choice D is, this is a stupid question. Well done. And it's true, you can use measurement periods for your part-time or variable hour employees. For someone you hire into a full-time position, no measurement period. You get basically 3 months, and after 3 months, if you don't enroll them in coverage and you're an applicable large employer, they could trigger a penalty. If they go to the exchange, if they buy federally subsidized coverage, you'll be likely subject to a penalty if you're an applicable large employer. I don't know if you can see that, it's dark, but it's the same thing. The cat's sitting on the book. The next to last question, or as we say if we're not saying de minimis, the penultimate question. This penultimate de minimis question is an applicable large employer's variable hour employee who actually averages 120 hours a month, is considered full-time. So if we go through the measurement period and they average their 120 hours, we consider them full-time. True? False? Partly true? Okay. The three people who raised their hands, one for each, were all correct. In general, for play or pay penalty purposes, it's an 130-hour standard. So the person who said false was right. For purposes of determining who is an applicable large employer, do you have 50 full-time equivalent employees? It's a 120-hour standard, not for penalties, but for determining whether you're subject to the rules. And so the person who said 120 hours, yes, that was right. That's who we count as a full-time person for determining whether you are or are not an applicable large employer. And the person who said partly true got both. And here's the last one. There you are, and soon to be in that state. Okay, so if an applicable large employer's employee is full-time, the person actually is full-time, that he or she will remain so for a stability period even after termination of employment. So they've earned their 130 hours a month average during their measurement period, they're in a stability period, and they terminate employment during their stability period. If you then say, we're cutting you off, you can go to COBRA, but no subsidy from us. They go to the exchange and say, I'm not getting affordable coverage. They're not paying anything toward it. I have to pay way more than 9.5% of my household income for it. Could you be subject to a penalty? Yes, true. Could be subject to a penalty if that person goes and says, my COBRA coverage isn't affordable. True? False? Partly true? Okay. I interpret that as exhaustion. Or D, who cares? What's the raffle prize? It's false. If they terminate employment, not if they go on a leave of absence, even an unpaid leave of absence, but if they terminate employment, they're no longer obviously your employee. They terminated employment. The fact that you're not providing them affordable coverage it doesn't have any effect about whether or not you could be subject to a penalty based on that person. And there you are. Okay, that takes us to something much happier, and that is some wonderful thank yous and some wonderful raffle prizes. Oh, thanks.